Hi, I'm Courtney Ross. I'm here with my partner, Dan Marusak. We're going to be talking about reductions and due process in the VA system. So, Dan, one of the really frustrating parts of the VA process is that VA at times will actually propose and reduce the veterans' ratings for service-connected disabilities. Now, the burden to show that a reduction is warranted is VA's burden, not the veterans. And it's a different legal standard as well to establish that the reduction is warranted.
Right.
Can you walk us through what the legal standard is for a correct reduction?
Sure. So VA must show that there was an actual improvement in the disability and that that it is shown under the ordinary conditions of life and work. So, actual improvement, that's a pretty high standard, I would argue. And oftentimes it's just the reductions are triggered just by an examination that might not match a previous examination or might show a lower severity in a condition than another one, a previous one. But, oftentimes we argue that that's not actual improvement. It doesn't show actual improvement. So that's usually the standard that's required.
Yeah, I see that all the time where one exam triggers the reduction, and what VA does is look at the rating criteria for that certain condition, and they just look at a checkbox in that exam that now matches a lower criteria that's set out by VA instead of actually considering this standard, which is what should be applied.
Yeah, and oftentimes with the DBQs, the disability benefit questionnaires, they're only looking at the check the boxes, like you said, and not the symptoms that are described in the examination beyond the check boxes. So oftentimes those don't show that there was actual improvement there. The veteran might say something like, my condition's gotten worse, which directly refutes the presumption that, or the fact that, actual improvement occurred. So
yeah,
it's important to look at what triggered it and if they're reaching that standard of actual improvement.
Yeah, to review those exams as a whole, which VA sometimes fails to do.
Yeah.
Now, for conditions that have been rated for long periods of time, there's a even higher burden on VA and a higher legal standard to show their reduction is warranted.
Yeah.
What's that?
So for conditions that have had a rating for at least 5 years, a rating that has not changed for 5 years, VA must show that the evidence makes it reasonably certain that the improvement will be maintained under the ordinary conditions of life. So reasonably certain, just another step above actual improvement. So it's an additional protective measure for conditions that have been in place for a long time.
Yeah. And VA regulations also recognize that for psychiatric conditions in particular, that those symptoms can wax and wane, certainly from exam to exam and from treatment to treatment. And so that further supports, especially for psychiatric conditions, that one examination should not be the reason in what VA is relying on to reduce a rating for a mental condition.
Yeah.
Now, VA, if they are going to reduce a rating, the law requires that they provide the veteran due process, so a chance to respond, which means they have to first issue a proposal to reduce the rating.
Right.
What is required to be covered in the proposal?
So the VA must identify the specific disability that they're proposing to reduce, and then the new proposed rating, as well as the veteran's new combined rating. So all three of those things should be in the proposal letter.
Yeah. And before we get into how to potentially respond, we will say, too, that VA takes the position that if a reduction won't change the combined rating, then a proposal is not warranted.
Yeah.
And so we sometimes see them just reduce without the proposal, right?
Right. So if a veteran's rated at 90% and a knee condition is changed from 20 to 10%, it might not impact the combined rating. The veteran might not drop from 90 to 80% combined. In our opinion, though, that still is a rating that is not favorable to the veteran, right? So if the veteran's trying to get to the schedule 100%, or another reduction might actually reduce them enough that they go to the 80%. So oftentimes we'll fight that and say, hey, you need to issue notice, or fight the reduction itself to try to get the rating back.
And it would still be relevant, too, if a veteran's trying to get to 100% combined. That reduction could set them back.
Exactly. Yep.
Trying to get there. So, okay, so back to the proposal process. If a veteran receives a letter proposing to reduce a rating, what are their response options and what are the timelines for that?
Sure. So you have 30 days. The veteran has 30 days to request a hearing. It's usually an informal hearing with a adjudicator assigned to the case, and then 60 days to submit additional evidence or argument to go against or refute the reduction. So we always recommend to do the personal hearing. It's usually very helpful to talk to the adjudicator, assign your case, and explain how your condition has not improved in any way. That actual improvement under the ordinary conditions of life and work has not happened. It can explain what happened at the examinations, if there were at the examination, if there was any issue with that as well. So our advice is to always request the personal hearing. Yeah.
And VA can't take any action on the proposed reduction until the hearing is held, which is often after the 60-day due process.
Right.
So it also means there's more time for reduction is implemented. Other types of evidence that you could submit if you weren't doing hearing might be written lay testimony, again, speaking to how there's been no actual improvement, any letter or a letter from a treating doctor or someone that you're seeing for that specific disability, and where they can speak to the severity of it and how it's impacting your daily functioning, could also be really helpful. Like Dan said, it just needs to be submitted within 60 days of that letter.
Or a family member or a spouse attesting to symptoms as well can be helpful.
So VA can't take any action to finalize the reduction until you've had the hearing or until the 60-day due process window has closed. If VA moves forward anyway and finalizes the reduction, when will the reduction become effective generally?
It has to be 60 days after the notice, correct?
Yes. Okay.
And then if they do issue a final decision reducing, the veteran still has appellate rights on that decision. So you can then go into the normal appeal process with either a higher level review or a supplemental claim or an appeal to the board, correct? So,
yes, absolutely.
Yeah.
And I would, one error I see VA make often when you do appeal final reduction is that they seem to then put the burden back on the veteran to show that they're entitled to a higher rating. The burden still remains on VA to show the reduction was warranted. And so you want to appeal with that in mind and ask for a restoration of a rating as opposed to just an increased rating.
Right. So the argument is that VA didn't meet the legal standard to reduce and not that you're entitled to a higher rating.
Exactly.
So it's a legal difference, but it makes a big difference, when you're on appeal, especially at the board.
Yeah, absolutely. When you're arguing that it should be restored. Okay, I think that covers generally the overview of the reduction process and how it works and what the appellate regs are. For more information, follow us at Green and Marusak.